The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to council and to all those who are watching us on our Kansas Supreme Court live channel. I would ask Mr. Doug Shima to please call the docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Friday, April 2nd, 2021 consists of one case. Appeal number 117216, State of Kansas versus Bruce T. Shockley, Wyandotte County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Your Honor, my name is Randall Hodgkinson. I'm appearing today on behalf of Bruce Shockley.
Madam Chief Justice, and may it please the court, State of Kansas appears by Assistant District Attorney Wyandotte County, Daniel Obermeyer, present and ready for argument.
Thank you, counsel. Mr. Hodgkinson, you may begin your argument.
Thank you, Your Honor. Just as a reminder, this is a direct appeal from a first-degree murder conviction out of Wyandotte County. The charge in this case stems from a shooting and death that occurred in December 2014. From that shooting and death, my client was convicted of first-degree felony murder and sentenced to life in prison. My intent today is to argue primarily about issue 1, which involves a statutory speedy trial claim on behalf of my client. Of course, the court may have other questions for me, but it felt to me as I read the briefs in this case like the biggest sort of disputes about the record or questions that there might be had to do with the statutory speedy trial case issue in this case. So just by way of review again, the facts aren't terribly disputed. What the facts mean in the case are pretty hotly disputed, I guess. But my client in this case was arrested and arraigned in February 2015, and the statutory speedy trial clock would have started then. And I think everybody agrees that my client was incarcerated, and therefore the state had 150 days under the statutory speedy trial limit to bring my client to trial. In May, my client appeared in court and had just been appointed a new attorney sometime shortly there before. And so the new attorney came to court and said, and requested a continuance and said, I've explained to my client that if he wants me to be adequately prepared, it will take some time past July, the then present speedy trial limit, past July, that will necessitate the waiving of his speedy trial to make that happen. And the prosecutor acknowledged.
Counsel, do you agree that the defendant's waiver of his speedy trial right at that time was unconditional?
No, not at all, Your Honor. In fact, as we move on in this discussion, the prosecutor acknowledges that the purpose of this continuance, of this request, was to allow counsel to process voluminous discovery. And so that's perfectly normal. That was the purpose of it. And the judge, the district court at the end of that hearing says, okay, I'm granting this, noting your waiver of the right to speedy trial, and says before you leave, get a new trial date and set it out far enough in advance so that you will have adequate time to prepare.
But that was after the defendant was finished with his waiver though, correct?
In the context of the hearing, the waiver was for the purpose of allowing his attorney to adequately prepare for trial. That he had a new attorney who said, and reasonably so, I can't get prepared for trial by July. I need some more time for that. And my client said, in response to that, I'll waive my right to speedy trial. And the judge recognized, all right, get a date, when you guys agree that you will be prepared for trial. And that date was September 28th, 2015. So certainly, Your Honor, it is our position, and I think the record establishes that was not an unconditional sort of plea, that it was done in a context. And the context was, this is a waiver of my speedy trial right to allow my attorney to get prepared. And the judge said, find a date when you will be prepared. And the parties agreed that would be September 28th, 2015. And in fact, the parties appeared shortly before that date upon the state's request for a continuance. And we know that my client's attorney was prepared on that date because they objected to any further continuance, that the purpose of the continuance in May had been fulfilled. And so it is our position that the continuance that was granted in May was for a specific purpose. That purpose was fulfilled by September, as evidenced by the fact that my client's attorney said, we're objecting to any further continuance here, and that everybody should have known at that point the speedy trial clock was back on.
Why should they know that? Because KSA 223401 simply requires continuance of a trial on showing of good cause, and the court found good cause.
Oh,
in addition, isn't it true that the state had alleged speedy trial's not a problem because it's waived?
Yes, Your Honor, that speedy trial was not a problem. And in fact, it wasn't a problem on September 25th. They had a lot of time still to take the case to trial. We're not disputing that the time between May and September wasn't counted against that speedy trial clock.
But how do you know which statute the court was referring to or the defendant was referring to when he didn't specifically say speedy trial?
I'm not sure I understand your question, Your Honor. Can you help me?
Well, an objection can be made under 223401 simply for lack of good cause. That does not invoke 3402, the speedy trial statute.
Oh, Your Honor, it's our position we don't need to have done anything else to invoke the speedy trial statute, that the speedy trial request in May was for the purpose of getting my attorney ready for trial. And that on September 24th, in this case, the attorney said, I'm ready for trial. And that the purpose of the continuance that was granted in May had been fulfilled. Now, there could be an additional argument about whether there should have been any continuance granted. That's not our issue here. It was fine. We're not raising any issue here today about whether a continuance was granted in September. That's not the question. The question is, did the trial court have an obligation then to understand that the speedy trial clock was restarted, and therefore we need to get a date within now the 150 days. The state still had 73 days as of September 28th, 2015 to bring my client to trial. So, the prosecutor said speedy trial was waived. That's right, they didn't have a problem. It wasn't impossible for them to set this case for trial within the 150-day limit on September 24th. They just failed to recognize, I think, that the clock was even started.
The question of whether that waiver was conditional or unconditional, is that a fact question? Can we determine that, or do we have to remand this to force the district court judge to do what defense counsel wanted them to do at the time of the hearing? And that is finding on this point.
I think that's an interesting question, Your Honor. And as I sort of prepared for this, I feel like my trial attorney in this case did a good job of trying to get the district court to make findings. But to the extent, what findings did the district court make? The district court said, is a defendant's waiver of his right to a speedy trial a blanket and an unconditional waiver of those rights? I don't think so. But I think in a reasonable sense and in a practical sense, it's a waiver and unconditional unless there's specificity referred. There is none. On one hand, the trial court said that wasn't an unconditional waiver. And in fact, I think a fair reading of the entire record is that the district judge was finding that my client acquiesced by failure to object at various points at the September hearing, at the January hearing where my client wasn't there. January non-hearing where my client wasn't there. And so, I mean, on one hand, I thought about coming in really forced, trying to argue that was a finding and that is a factual finding, that wasn't unconditional. It was just the subsequent conduct of my client that sort of constituted acquiescence, which is the separate possible argument, and which I think is soundly defeated by this court's precedent, that at most there's sort of passive acceptance after that date. But Your Honor, I mean, to the extent that you think it is a fact, I mean, I think the record's clear based on our argument that the continuance requested in May 2015 was for a specific purpose and to a specific date. I mean, that wasn't a specific date discussed at that hearing, but the judge said, find a date when you will be prepared to go to trial, counsel. And that date was September 28, 2015. And so, so our argument would be, I don't think you need to remand it, because I think based on that record, it's not unconditional. It was for a specific purpose to a specific date. Now, if you disagree, if there's something that else you need, yeah, I guess you could remand it and say, Judge, find out what the deal here was, find out what the client's intent was, if that's somehow like a fact that you need to know. But I think the record in this case is crystal clear from that hearing that the intent, the purpose of that continuance was to allow my attorney to get ready, and that my attorney would need until September 28th to get ready, and that by September 28th, my attorney was ready. And that everybody should have understood from that record that the speedy trial clock had started again. Now, it didn't mean that there was a problem on September 28th. The state still had 73 days to bring my client to trial within that 150-day limit.
Counsel, what do we do with the fact that on that second hearing date, when the state's making its motion for its continuance, the state's counsel specifically says the defendant did a prior waiver of his speedy trial rights, so there's no speedy trial issue. And immediately, I mean, just a few lines of the transcript later, the defense counsel's getting up and he's simply arguing that the state had failed to meet their threshold requirement for a motion to continue, and doesn't correct anything about the statement about the speedy trial, so that the judge knows that that's in play.
Your Honor, the prosecutor was correct. My client had waived speedy trial from May to September. So there was no speedy trial issue on September 28, 2015. They still had plenty of time to bring my client to trial. They just didn't set it in a date within that 150-day limit. It wasn't the prosecutor didn't say, Your Honor, we don't have to worry about any time period on this because this client has unconditionally and forever waived his right to speedy trial till the end of time. That's not what the prosecutor said. The prosecutor said he waived it. That's right. That's correct. He waived it from May to September. So we've got plenty of time here. They just didn't do it within the time limit set. Your Honor, my time's running out, so I haven't even gotten to talk about January 11th yet. And the fact that whatever happens then, and that September hearing, the case is set till January 11th. And the record, I think, is pretty clear. There was no hearing. There was no opportunity for my client or the attorney even to object to the trial court's continuance based on a crowded docket. And even if we say that crowded docket exception could apply, and there's no findings in this case to support that, that only allows a 30-day exception period under the statute. And the district court far exceeded that in this case. So we think for two reasons in this case, at 2 points, the trial court blatantly violated my client's statutory speedy trial right. For those reasons, we would ask, as you've recently done, to recognize the importance of that and reverse this conviction and remand with directions to discharge my client. Thank you.
So just to clarify, you would say that because of the lack of an ability to object at that January hearing, that has to count for against the state, perhaps except for the 30 days for the speedy, if we would count that as a speedy trial continuance.
Your Honor, yes. I mean, I would argue, and I just don't know if this is adequately done in the brief, I mean, but that especially based on your recent case law, that without a hearing, there's no findings really to even support the crowded docket finding, because there was no hearing and no opportunity to actually sort of get any information about that. But even if that's wrong, even if you say, based on the record we have there, you know, the judge appears to say there was and certainly there's plenty of evidence that there was another case going on that day. Whether there could have been another judge that could have taken this case, we don't know, because there was no hearing. But yes, the ultimate answer to your question is yes, that even if that crowded docket exception applies, that would only be for 30 days and not the remainder of that time period, which would then not be my client's fault, is how I would say it is. Wasn't because of delay because of my client. It would be a mistaken, there's no showing of acquiescence on the part of my client to that extra time.
Counsel, does that matter if we disagree with you and find that there was an absolute waiver?
No, I mean, the answer to your question is no. If you find that by saying what my client did in the context at that May hearing, that he forever and for all time waived his statutory speedy trial right and cannot get it back based on conduct, then yeah, obviously you're right that there would be no speedy trial violation if that's the case. Now that will be an interesting, you should maybe think about remanding in that case with regard to ineffective assistance of counsel, if that's what the lawyer allowed his client to do.
That goes to my next question, which you kind of addressed, but maybe not directly. As I read the record, it looks like the district court actually made a finding that the defendant did absolutely waive his speedy trial rights. What do we do with that finding?
At the May 2016 hearing, Your Honor?
Well, I'm actually not sure which hearing I'm looking at, but the court states pretty conclusively, I'm concluding and I'm stating for the record, the defendant waived his rights to speedy trial.
What? My client clearly waived his right to speedy trial in May 2015. It's just, did he waive it forever? That's not what the district court said.
Well, that's not how the district court said that it's an absolute waiver unless there's specificity, and the district court specifically said, I find no specificity.
I mean, Your Honor, my answer to your question is, I mean, you talk about it being unambiguous, and I mean, let's look at the whole quote. The court says, is the defendant's waiver of right at speedy trial a blanket or unconditional waiver of those rights? I don't think so. And then the next sentence, but I think they're in a reasonable sense and in a practical sense, it is a waiver and it is unconditional unless there is specificity referred. I think that's what you're talking about, Your Honor.
And he says, I find there's no specificity.
There is none. But I mean, specificity in what regard? Because he's talking about in the context of the holding, he's talking about the conduct of the attorney in this case and failure to object down the road, not what was done at that May hearing. So I guess I would dispute then that it's that unambiguous. And maybe to Chief Justice's point, I mean, if you have a question about that, what the judge's holding was in that regard, remand could be appropriate. But I think when you look at the context, okay, thank you, Your Honor.
Just real quick, your point is the district court never actually made that finding, as opposed to, yeah, the district court made that finding, but it was wrong.
That's right. I mean, the district court, to the extent said it wasn't a blanket and waiver, but as I sort of read it, the court's sort of saying, but because of your conduct afterwards and failure to object, it's as a practical matter, it's unconditional. And that's not correct under this court's precedent. That's just not correct.
Any other questions? Thank you, Mr. Hodgkinson. Mr. Obermeyer?
Madam Chief Justice, and may it please the court. In the early morning hours of December 16, 2014, Melvin Lone was shot dead on his front porch when he went outside to investigate some strange noises. The defendant, an ex-boyfriend of Melvin's daughter, Rachel Smith, was identified as a suspect in the case. Because of the defendant's physical violence against Rachel in the course of their relationship and acts of intimidation, including slashing her tires, Rachel felt it was necessary to involve police. In a series of text messages sent in the evening hours of December 15th, 2014, the defendant was clearly displeased with this series of events. He specifically said in one text message, "You fucked up. Police kicked in for me, and since you don't have anything, to say, I'll just assume. Thanks for the closure. Just kill me." The defendant's associates on that evening and early morning provided details leading up to the shooting and killing of Melvin Lone. Trial testimony from DeAndre Williams and Abby Knight and preliminary hearing testimony from Peyton Osborne, who was not available for ultimately a trial, generally established that the three of them and the defendant had driven from a location in Johnson County to Lone's residence in Wyandotte County. While they drove past on one of their passes, the defendant opened fire on the porch, and those shots killed Melvin Lone. The Wyandotte County jury convicted the defendant of felony murder and criminal discharge of a firearm into an occupied dwelling, as well as felon in possession. Taking the issues in this case as they're presented, the defendant's speedy trial rights were not violated in this. And mostly that's due to the fact that there was an unconditional waiver in this case. Specifically in volume 3, pages 4 and 5, the court inquires of the defendant, "Sir, do you understand what your right to speedy trial is?" The defendant, "Yes, Your Honor." The court, "And you've discussed this with your attorney?" "Yes, Your Honor." "Do you have any questions about that right for either the court or your attorney?" "No, Your Honor." "And it's your intention to waive that right here today?" "Yes, sir." That, as the court later noted, was maybe not a unconditional waiver for all time, in the sense that the defendant can't reassert his rights to speedy trial, which he certainly could do. But it is up until the point where he decides to reassert his speedy trial rights. And we simply
counsel, is that true when when it's made in the context of a continuance? Do we need to look beyond that limited colloquy to the context in which the issue arose, as the defendant suggests?
I think that you can, but that should weigh very little in this court's analysis, simply for the reason that if this continuance is only waived up and to the extent that it's necessary for defense counsel to prepare for trial, then that should be specified. And when we get to the point in September where the state is requesting a continuance, that can be and should be reasserted. Defense counsel can say, "We've had our continuance and we're ready for trial now, and me and my client would like to reassert that right." Make it unequivocal.
Just a general objection to a continuance reassert a speedy trial right. Why are there magic words that have to be said at that point? Especially in light of our case law that says just mere acquiescence in a continuance isn't necessary. You don't have to object necessarily. You can acquiesce, but that isn't a waiver of your right.
Certainly, I don't disagree with that at all. But this case is distinguishable simply because we don't just have a mere acquiescence; we have an affirmative waiver of rights. The defendant in his brief cites State v. Mitchell, and I think that Mitchell does provide good guidance to this case, because essentially what that in that case, ultimately the court did find a speedy trial violation, but the reason why it found a speedy trial violation was because defense counsel specifically invoked the right to speedy trial as it relates to his objection to the court's or the state's interlocutory appeal. Now, why is that important? Because it puts the state on notice and the court on notice that the speedy trial statute is back in play. We have to know, the state has to know, and the court has to know, in order to protect the defendant's speedy trial right, when exactly.
Let me just get to that. Whose responsibility is it to make the determination of speedy trial and to ensure speedy trial? I mean, the statute is clear, our case law is clear that it is the court and the state, not the defendant. And it seems to me you're shifting the responsibility or the burden to the defendant to remind the court. That's not up to the defendant or the defendant's responsibility, is it?
Oh, no, certainly not, Justice Rose, and I didn't mean to imply that. But in order for the court and the state to make sure the defendant's speedy trial rights are not violated, they have to know that those rights are back in play once a blanket waiver is given, as it is in this case.
Why don't they have to ask that question? Why, when you ask for why when the state asks for a continuance, isn't the burden on them to assure there's a record that there's a waiver of a speedy trial?
Chief Justice Lukert, I believe that the parties and the record in this case indicates that the state did believe that the speedy trial right had still been waived and that waiver was still effective. The prosecutor noted that the speedy trial right had been waived by the defendant so that there was no problem in that regard. Defense counsel didn't dispute that fact. Defense counsel merely objected to the continuance request on good cause shown. And something that counsel said while I'm thinking about this, indicating that defense was ready to proceed to trial, that both the state and defense prior to the September setting, both had, the state had its motion to admit defendant's statement and the defense had its motion to suppress the defendant's statement, both on file and pending before the court. The reason why the continuance was requested was because one of the state's witnesses, one of the detectives who took the defendant's statement, was no longer available to testify at that. So it was necessary to have a continuance at that point if the witnesses weren't available. There was a medical emergency. The prosecutor proffers the reasons for that in the record. I won't rehash that here. Also, I would note that prior to that September setting, I believe it was 4 days before trial, the defendant filed a late notice of intent to present an alibi notice. So also that had to be something that was dealt with. Ultimately, moving the trial mooted that issue, so that there was no issue with the defendant's purportedly late notice. So we can say that the defendant was ready for trial in September, and theoretically that may be true, but we still have these outstanding motions that the court needs to deal with.
And would you agree that, at least on the record before us, there's no way to determine that the defendant had an ability to make an objection to re-invoke the speedy trial when the last continuance was granted?
In the January setting?
On the court's own motion?
Chief Justice Lukert, just so I understand your question, that's on the January setting for trial?
To continue it from there to the May setting?
Yes. I would argue that the defendant and defense counsel both have the opportunity to file a motion at any point before or after that trial setting and re-invoke the right to speedy trial. And then the court would have to take it up. Now, we know as a practical matter that the new trial date from January to May did not appear out of thin air. The court would have had to consult the attorneys, make sure that their calendars were available for an agreed to date. That usually involves back and forth, either attorneys saying my witnesses won't be available that day or I'm not available that day, and the court having to take that into consideration. So at any point before the May setting, the defendant can object to that. Now, ultimately, defense counsel did file a motion alleging a speedy trial violation, but I believe that that also was filed 4 days before the trial was set to start in that case, which raised another issue which the court had to deal with. And then that—
Counsel, didn't he also reassert the right to speedy trial at that time, right before the motion was heard?
At the May setting, Justice Wilson?
Yes.
Yes, I would argue, I think that that's a fair reading, that when the defense counsel files the motion to alleging a speedy trial violation, that's showing that he wants to reassert it. And again, we don't have any of that beforehand. And just so I'm clear for this court, I think that it's important when a defendant does give a waiver of speedy trial rights at some point, and the parties are clearly relying on that for scheduling purposes, and the court's relying on that too, there has to be some true indication that the right to speedy trial is back in play. As this court knows, it is a very harsh penalty for the state and for the people when speedy trial rights are violated, ultimately resulting in dismissal of the case. And that certainly changes, or should change, the calculation to any attorney's thinking as to whether or not speedy trial is in play and whether or not the conviction is in jeopardy because of when a trial is scheduled. The defendant sent an letter of support of additional of State v. Queen, which this court recently decided, affirming the Court of Appeals dismissal of a case based on a speedy trial violation. And this case is distinguishable for the very important reason in that the trial court and the prosecutor in that case should have noticed that there was a speedy trial violation. They should have noticed, but they missed it. Here, the trial court and the prosecutor, it's not a clear call at all. Now we're having on appeal the argument that the right to speedy trial was invoked back in September. And that argument was made at the district court, but it was only made in May. So we have a distinguishable set of facts here that I think is important. So certainly I'm not asking this court to give some magic words, but there has to be a clear indication that that is the important thing that's at stake. Unless there's any other questions on issue 1, I'm prepared to move to issue 2 briefly.
Would the trial, if we accept the defendant's analysis, would the trial have been timely if it had occurred in January?
I believe so, Justice Wilson, because then we would have the subsection E3 exception granting for good cause shown. So that would be from September to January, and if I'm remembering correctly, that would be within the appropriate statutory period. So I do not believe that we have that there. And it's important to note that the E3 exception wasn't raised at the district court level, at least not explicitly. And I think that goes further to show that parties are thinking that the statutory right to speedy trial simply isn't in play in this case. And one more thought as to whether or not a waiver of speedy trial is conditional when it's given in a case like this. Suppose we have a slightly different set of facts. Let's say in September, the defendant expressed that he wasn't satisfied with his current counsel. And so new counsel would have to be appointed. Well, naturally, new counsel would have to be brought up to the case just as the replacement counsel originally did. And this is not a far-fetched scenario. I've seen this happen in my own career, where we're getting close, where we have a waiver of speedy trial at some point, but then the defendant, for whatever reason, causes something that a conflict between his attorney, so that the attorney can no longer represent him. Is the district court supposed to obtain another waiver of speedy trial at that point so that this attorney can get caught up when he already has a waiver previously? I would submit to this court that that's that the reasonable reading of the waiver is that it is effective. In closing, I would rest on the merits of the briefs for issues 2 and 3. And ultimately, I would ask this court to find that no statutory speedy trial violation occurred and to affirm the defendant's convictions and sentences.
Thank you, Mr. Obermeyer. Mr. Hutchinson, you reserve 3 minutes for rebuttal.
I just have 2 points, Your Honor. First of all, I just want to make it clear that Mr. Obermeyer is parroting speculation from a brief that I know he didn't write, but this idea that, well, they must have consulted, the district court must have consulted with the attorneys in January. And Your Honor, I would just note there's nothing in the record on appeal to support that. They're talking about speculation that is not supported by the record on appeal. In fact, when they're having a discussion about this in May after that, defense counsel says, Judge, I never had, and my client never had the opportunity at some sort of hearing. I mean, this isn't a situation where they were all in chambers talking about it. I mean, because if that was the case, I think when defense counsel said, we never had an opportunity to respond to that, the judge would have said, yes, you did. We were all sitting in chambers together. The judge doesn't say that at all. It may be the case that it's very typical for judges to talk to lawyers about rescheduling dates, but I think district judges can tell people when to show up at different places. And that appears to be what happened in this case. The state's saying, but they could have objected later. That's just another way of reframing this idea of you have to object or you acquiesce. And that's exactly what this court just reaffirmed is not the law in Kansas. My second point.
Well, go ahead and make your second point. And then...
my second point, Your Honor, is, the state's saying you don't have to use magic words, but that's exactly what they're saying. They're saying you didn't use the magic words at the May 2015 continuance hearing, that if my client had said, I guess, Your Honor, I waive my right to speedy trial just long enough for my attorney to get ready, they would have acknowledged that that would be limited in that way. And my client didn't say that. In the context of the continuance, it's obvious that's what my client is doing. And even the district court recognizes when granting the continuance, find a date far enough out for you to get ready, that is the purpose of that continuance. They say, well, you don't have to say magic words in September to re-invoke, except yeah, you do, I guess. You have to say, we are invoking the speedy trial right again. It's not clear by our objection to a state's continuance that we want to go to trial in this case. Again, I don't think this court's law supports this idea that you have to say magic words at either the continuance or at the time when the trial is reset. If the context of this case shows what the purpose and length of that continuance was, and that was fulfilled, that everybody should know the speedy trial clock started. And we shouldn't have to say any other magic words. Even trial counsel recognized he didn't say any magic words in September because he didn't think he needed to. He thought it was clear we're back on the clock.
For that period of time that relates to the continuance because of the unavailability of the detective, does that really get charged to the state, or is it charged to the defendant who had a motion to suppress pending? And I know, is that one that comes down to whether or not the trial court order of just cause to be able to handle that hearing has to be considered, and if there was just cause, then it is a defense to the delay?
There was no showing that there was no showing, Your Honor, and I'm trying to think to be clear here. I mean, there was no showing that the defendant wasn't ready to go on that motion, on their own motion. The fact that once the state's motion for continuance is granted, we say, well, let's put them all off. I don't think you can charge that to the defendant. I mean, it's still the state's request. There's no showing or agreement that, well, good, we weren't ready to go either. They were ready to go to motions. Maybe that would have changed, what happens down the road.
Is that the test, or is the test that the judge determined that the detective's testimony was necessary, a necessary part of the evidence for dealing with the Jackson v. Deno issue, regardless of which side had raised it?
Yeah, with regard to the state's, let me clarify. Are you asking, is it like a Jackson v. Deno hearing always chargeable to this defendant? Is that your question?
In a way, perhaps, yes.
Yeah, no, I mean, the state's coming in wanting to get a ruling on the admissibility of evidence, to make sure that, for example, the trial attorney doesn't in the middle of trial say, Your Honor, we think this is inadmissible. I mean, that's still the state's motion. So the fact that it might be for the benefit of a defendant doesn't mean that it's caused by or delay caused by the defendant. I mean, maybe the defendant's like, we're fine waiting until trial to bring this up.
The defendant's motion, but the burden of the state, isn't that different? I mean, there's not a Jackson v. Deno hearing unless the defendant requests it, right?
Oh, yeah. No, I mean, the state can request a Jackson
burden, but it's the defendant's motion.
Your Honor, I'll need to review the record here. I mean, in regard to what the posture, because the state can request a Jackson v. Deno hearing too. And so now I'm worried that I'm I'm not accurate with the record.
And this was essentially a motion, a Jackson v. motion to suppress, wasn't it? That was brought by the defendant.
I'll have to, I don't know standing here, Your Honor.
Yeah, okay.
But the delay is still not caught. I mean, the defendant's like, we're ready to go. If you don't have your witnesses here, that's understandable. That might be why we grant a continuance, but that's not the fault of the defendant at that point, even if it is the defendant's motion. Still delay caused by the state.
Any other questions? Thank you to both counsel. We will take this appeal under advisement. Court is now in recess until